Hi there, welcome friends to the Sunday edition of The Burning Question. The fact that you're watching News Sunday shows how seriously you take what's happening around you and in the country. So let's have an hour of engaging news conversation. The BJP seemed to be on the back foot today as it sought to distance itself from comments made by two of its MPs, Nishikant Dubey and Dinesh Sharma, for targeting the topmost court of the country and its Chief Justice. The comments came the same day that Tamil Nadu Chief Minister M.K. Stalin used the term postman as a pejorative for Governor R.N. Ravi, calling the office of the governor a mere postman in the constitutional scheme of things. In the background of this war of words between all sides of the political divide is a Supreme Court judgment on the Tamil Nadu government versus governor fight over 10 legislations that happened last week and which went in the favor of the DMK government in Chennai. Since then, we have seen an open season of politics panning out in a manner so as to paint constitutional institutions in poor light. Such has been the free-for-all that one newspaper went on to reduce the office of the Vice President of India into a ceremonial inconsequentiality. Do not forget also that 5 states have refused to implement the Waqf law passed by the parliament. One state, Tamil Nadu, has even passed an autonomy resolution. In this jousting for their own political positions, are institutions being attacked? Is the constitution being subject to stresses of politics that can have long-term consequences? Are bad examples being set? Who's holding the brief here for the constitution really? This is a burning question tonight. Let me get you the headlines first.
के लोगों का बहुत ही वेल प्लान्ड प्रोग्राम चलता है, उसके लिए फंड्स लगाते हैं ये लोग. तो ये जो कुछ कहा गया, ये भारतीय जनता पार्टी की अपनी सोच है.
BJP MP Nishikant Dubey faces backlash over remarks on Indian judiciary. Opposition leaders demand his resignation while BJP distances itself.
आज गवर्नर साहब के साथ हमारी बात हुई है, चर्चा हुई है और जो हमने 2 दिन का प्रवास किया था उस अनुभव के बारे में यहाँ पे महिलाओं ने, बच्चों ने जो हमारे साथ जो बातें करी है उसको मैंने उनके साथ आज मैंने रखा है.
NCW panel meets Bengal Governor Sivananda Bose at Raj Bhavan, apprises him of current situation and violence at Murshidabad and Malda districts of Bengal. Former Karnataka DGP Om Prakash Rao found dead at his residence in Bengaluru, wife being questioned in police custody. Shops washed away, vehicles submerged and 3 lives lost. The situation in Ramban remains grim as multiple rescue teams deal with the aftermath of the flash floods. And it's US Vice President J.D. Vance's first visit to India. Key bilaterals with Prime Minister Modi lined up on Monday. Top focus on Indo-US trade talks. Well, ladies and gentlemen, if recent public statements by leaders holding top public offices are any indication, there is a clear encroachment on institutional autonomy and sanctity, either by design or default. From Vice President Jagdeep Dhankhar's scathing indictment of the Supreme Court, Tamil Nadu Chief Minister's spokesman jibe at Governor R.N. Ravi, to BJP MP Nishikant Dubey's explosive charge hurled at the Chief Justice of India. The neutrality and functional autonomy of institutions are being called into question. But does it set the right precedent is our question. Look at this report and then I come back for a conversation.
Vice President Jagdeep Dhankhar's scathing public critique of the Supreme Court was followed by a series of public statements questioning and running down holders of high offices. Amid the clash with the centre over language and delimitation, Tamil Nadu governor adopted a resolution in the assembly for setting up a panel to push for autonomy. In an unsavory remark after repeated run-ins with R.N. Ravi, Chief Minister M.K. Stalin said that governors are mere postmen between the centre and states. Even as Vice President Jagdeep Dhankar's strong assessment of the judiciary raised political frowns, BJP MP Nishikant Dubey grabbed headlines for all the wrong reasons. Picking up from where Dhankhar left, Dubey said that the parliament and assemblies should shut down if the Supreme Court takes the onus of lawmaking on itself.
1942 की प्रिवी काउंसिल की जजमेंट है, उसमें यह कहा गया कि जहां कानून नहीं लिखा हुआ है उसके बारे में यदि प्रिवी काउंसिल या सुप्रीम कोर्ट कोई जजमेंट देती है तो बात समझ में आती है। यहाँ पूरा जजमेंट लिखा हुआ है कि राष्ट्रपति का क्या अधिकार है, उपराष्ट्रपति का क्या अधिकार है, प्रधानमंत्री का क्या अधिकार है, हमारे पार्लियामेंट का क्या अधिकार है, हमारे सुप्रीम कोर्ट का क्या अधिकार है, हाई कोर्ट का अधिकार है। जब सब कुछ लिखत पढ़त में है तो तुम नया कानून कैसे बना दिया? 3 महीना कहाँ से लेके आ गए कि राष्ट्रपति को 3 महीने के अंदर फैसला करना है? ये किस कानून में लिखा हुआ? इसका मतलब ये है कि आप इस देश को एनार्की की तरफ ले जाना चाहते हैं और एनार्की जो है इस देश में बर्दाश्त नहीं होगी। जब नया कानून आएगा, जब नया पार्लियामेंट बैठेगा, इसके ऊपर विस्तृत चर्चा होगी। इस देश में धार्मिक युद्ध भड़काने के लिए केवल और केवल सुप्रीम कोर्ट जिम्मेवार है। सुप्रीम कोर्ट अपनी सीमा से बाहर जा रहा है और सब कुछ के लिए सुप्रीम कोर्ट जाना है। इस संसद का कोई मतलब नहीं है, विधानसभा का कोई मतलब नहीं है, उसको बंद कर दो।
Not stopping at that, he accused Chief Justice of India Sanjeev Khanna of being behind the civil unrest in the country over the Waqf law.
इस देश में जितने गृह युद्ध हो रहे हैं उसके जिम्मेवार केवल यहाँ के चीफ जस्टिस ऑफ इंडिया संजीव खन्ना से।
In a fiery address that made national headlines, Dhankhar, a lawyer himself, questioned the Supreme Court's power to dictate what the president and governors should and should not do.
When parliament is defined, according to you, parliament is Lok Sabha, Rajya Sabha. No. Parliament, the first part is the president. Second and third are Lok Sabha and Rajya Sabha. There is a directive to the president. By a recent judgment, where are we heading? What is happening in the country? We have to be extremely sensitive. It is not a question of someone filing a review or not. We never bargained for democracy for this day.
The statements raised larger questions on whether institutional autonomy and the constitution itself were pawns in the hands of politicians going at each other. As the war of words peak, are politicians setting the wrong precedent by calling institutional sanctity into question?
All right, joining me in this conversation, Pulla Rao, political analyst, leans towards the DMK, here to defend the Tamil Nadu government, live from Chennai. We also have Anirban Banerjee, pro-TMC voice, joining us live from Kolkata. We have Abid Mir Magami, a spokesperson of the Congress party, joining us live from Srinagar. We also have Rajat Sethi, columnist, analyst, leans towards the right, live from Delhi, there to defend the BJP and the centre. We also have Rahul Ishwar. He's a High Court lawyer, also a political commentator, leans towards the right generally, live from Trivandrum. And I want to begin with the advocate Dinesh Jotwani. He's joining us as a constitutional expert. And let's try to understand, Mr. Jotwani, what we are seeing panning out in the country over the last few days, particularly in the last 24 hours, with the kind of comments that have been made by both the sides. That is this a case of judicial overreach in the Tamil Nadu verdict, or is it becoming a case of politicians overstretching? Mr. Jotwani, can you unmute yourself?
Oh, yes. Sorry about that. I believe that there has been overreach from both the sides. We have a very balanced constitution. We have seen, and it is an active constitution. We have seen how judiciary is empowered to look at legislation which violates fundamental right. At the same time, we have given legislature, we saw in Shah Banu case also, we have seen that legislature also has supreme power to enact laws. So what has happened recently, I would say, has been that there has been statement made, and statements have been made by senior people in the government and in the opposition, if we see, challenging each other. The constitution has worked very well over several decades, and we don't need a proof of that from anyone. Yes, there have been, I think, overstepping that has taken place, but that is subject to remedy. That is subject to reviews that can take place. At this point of time, I know if we talk about the Waqf Board enactment and the stay on it, we would see that Supreme Court, it's an interim stay, first of all. No final verdict has come so far.
Yeah.
So we cannot at this point of time say that there has been any decision made on that. So I think if we wait for a few days, we'll see that the balanced judgment and the balanced verdict comes from the Supreme Court of India.
Okay. The fact of the matter is that it seems to me that maybe the Supreme Court did overreach. Rahul Ishwar, if I can get you in here, because we remember the Sabarimala case, and it was seen that whatever Supreme Court pronounced by way of its verdict was really not liked by a majority of stakeholders in that case. Similarly, now we are seeing Supreme Court, while there might be some virtue in the position it has taken vis-a-vis the Tamil Nadu government versus the governor case, stretching it to include the president or to pass instructions in a manner that really challenges the provisions of the Constitution. I think there does seem to be an element of overreach in the Supreme Court which is getting these kind of reactions.
Let me be 100% honest, 100% balanced, and 100% neutral in it. We have the highest respect for Supreme Court, and Supreme Court is the watchdog of the Constitution. But both sides, by both sides I mean Supreme Court and government on the other side, they should have a ceasefire in this matter. The reason being, yes, there are some issues with Tamil Nadu. We have been debating that a long period of time. But it is for the first time in India where the state law took into effect without the signature of governor or the president. So is it not an instant of overreach? Many people who are very critical of BJP are also raising the question. Because the point is, when Supreme Court oversteps or Supreme Court has overreach, I'm using that word in the highest of respect, when Supreme Court seems to have that kind of a overreach and instructing some kind of a deadline which is not mentioned in the Constitution, it is raising eyebrows. Because we all see Supreme Court as an institution which is beyond politics. It is not politicians. It goes without saying that Dubeyji's statement is wrong. Sri J.P. Nada itself distanced clearly and said we will never endorse a statement. Whether what Dinesh Sharma ji said or Dubeyji said, I don't think anybody in their right mind will agree. Whether it is BJP, Congress or CPM or any other party, doesn't matter. We shouldn't attack judiciary. We shouldn't name Chief Justice and say things like what he said. Having said that, what VP raised is a very important point of debate. Yeah, the language can be debated. The language, whether the nuclear head, we can debate that. But the point our Vice President raised is questioning the balance that we have to take. That balance should be maintained because the Constitution itself says balance of force. We have to balance between the judicial autonomy. At the same point of time, the government has a right to make policies, or the other side also. So it's a very thin line, and I hope Supreme Court themselves will correct it. And if Supreme Court had to hear, and just one last point, if Supreme Court had to hear, a 5-member bench had to hear and give this answer on a very substantial legal question. So everyone who is even not BJP is having apprehension whether Supreme Court has overstepped. It is up to the top court to clarify it.
Yeah, absolutely. And Rajat Sethi, if I can get you in for your first comments, why is the BJP so defensive? I mean, I heard Dinesh Sharma and Nishikant Dubey. Maybe Dubey was being Mr. Dubey was being a little provocative. But what has Dinesh Sharma said? He's not saying, I don't find anything wrong in what he's saying. He said, I don't want to comment on the Honorable Supreme Court. But people have this doubt when B.R. Ambedkar made the constitution, there was clear and well-defined division of power in the constitution of Baba Saheb Ambedkar. And the legislature makes laws according to it. The Supreme Court interprets those laws. Nobody can dictate parliament as to what laws to enact. I mean, Mr. Dinesh Sharma stops there. Nishikant Dubey really pushes the envelope, says that the Chief Justice perhaps or the court should be held responsible for the kind of anarchy we are seeing in the country. But why is the BJP so defensive, you think, Rajat?
I think, where perhaps Nishikantji erred was by naming the Chief Justice Sanjeev Khanna. I think that if he could have avoided, the message that was there, that in a parliamentary democracy, parliament and the laws that flow from the parliament have to be paramount. Till there is not something which is grave constitutional mistake that has crept into those laws. Barring those very, obscure events, Supreme Court shouldn't be going in that direction. But moreover, any institution for that matter in a democracy, if it starts assuming that it is infallible and not subject to any criticism, that is the start of decay of that institution. And for very long, the public, we the people, we have given, and we are equal stakeholders in this negotiation. When we are saying that the Supreme Courts and the judges and their conduct and their public demeanor, etc., is reaching a tipping point, it is for this institution, the Honorable Supreme Court, which needs to hear the writing on the wall. It is evident there is some kind of dissonance. It is not falling in tune with what the people of our country expect and hope from our institutions. There is severe accountability through multiple ways on the executive, because every 5 years there's an election. What bigger accountability can be there? And similarly, for the parliamentarians, they also have to go through that accountability test. Where is the Supreme Court's accountability test? And if the Honorable Vice President, uses an opportunity to table his concerns, he's voicing a lot of our opinions. What we can't do, because we would be attacked for the simple case that we are going and speaking against the Honorable Supreme Court. Where is that window where constructive criticism can appear in public discourse? And therefore, I absolutely 100% stand with the Honorable Vice President. I would also go on to say that BJP has been needlessly very risk averse in this whole thing, primarily because, attacking the Supreme Court, the Congress party jumps on this thing. They want to make a political hue and cry that, okay, Baba Sahib's constitution and his institution is being attacked and blah, blah, blah. They can go on a narrative and fool the people around on the streets. That is what I think the BJP is fearing. But till the point Nishikantji does not take the name of and individually, mark out the Honorable Chief Justice, till that time, all his arguments are fair. He himself is a member of parliament, and he has every right to question what he intellectually feels is defeating the core purpose of infallibility of institutions in our country.
Absolutely, even I thought so. And let me take this to Pulla Rao then. Pulla Rao, your chief minister calls the governor a postman. Is that in keeping with the decorum that constitutional office demands, Pulla Rao? I mean, the opposition is trying to rail against the BJP on the issue of Nishikant Dubey comments. But look at what your chief minister has called your governor, a postman.
You see, I'm glad you finally came down to the man who started this whole crisis. A man who's, these are small, dangerous signs. You're bringing down the Constitution. You're bringing down established institutions. For the last 6 months to 1 year, it's very, very, very sad. I heard our three distinguished friends, Mr. Ishwar, Seti, and the senior advocate, Jotwani. I do nothing bad about what they said. We can all accept it. But look at the governor. He walks out of the Tamil Nadu legislature opening. He comes to court. He's on extension. He has already been warned once to not hold files like this. Is there 28 governors, I think? I am subject to correction. Is any other governor creating this kind of situation? Why do you create a situation? Article 142 gives the power to Supreme Court to do complete justice. If you chastise the governor, put a limit on the days he can hold the file, and not the president, it doesn't work, number one. Number two, you go into our constitution, like all constitutions, are ambiguous. They leave that room for discussion and for dignity and the play of decorum. Is the governor shown any decorum? I don't know. I'll be very happy if they say yes. Look at the way. What was the cause? What are these files? Are they earth-shaking files? Is there some great constitutional issue is haggling over? Or merely trying to get an extension as this term is over in August 2024? How can you allow a governor to spoil the constitution? If there's an aberrant person, you remove him. The constitution is above everyone. The country is above everyone. Can't you have? What is the meaning of this? Coming to court, going to Supreme Court. What is the meaning of it? As the court said, the governor is a friend, philosopher, and guide. There were so many other governors in Tamil Nadu earlier. I'll quote another very distinguished IPS officer. Ramon Rao was a governor during Jayalalitha's time and Karunanidhi's time. He had issues. He dealt with it privately, I'm told, and they obliged him. Tamil Nadu's government is a very old government.
Are you suggesting, Pulla Rao, that it is just personal with R.N. Ravi and not necessarily about the constitutional provisions in the system? Because the debate seems to have gone much beyond that. Because using this opportunity, the Supreme Court has even taken into its ambit the office of the President of India. So it's not just about R.N. Ravi, it's about the office of the governor and ultimately about the office of the President also, as it turns out now after the Supreme Court verdict.
You see, when the elected legislatures, government, executive does wrong things, it cedes power. It cedes power to the courts and to other bodies. That's what they're doing. There is no need for anybody to have made these statements. I don't want to mention Mr. Dubey's name and all that. Why should they make these statements? Is it going to help? They know it won't help. They know it is unnecessary embarrassment. They just give a statement.
No, what's wrong with that? See, Nishikant Dubey is saying that if legislation becomes the business of the Supreme Court, then shut down the parliament. I mean, is it wrong to say that as per the Constitution, the power of legislation, and there is a clear division of power, the legislation, the function of legislating, making laws in the country belongs to the parliament. It's the sovereign function of the Parliament of India, of which the president is an integral part.
Can they pass a law tomorrow? Can they provide the Supreme Court there to check the parliament, to check the legislature? Can they pass a law saying that all property is no longer belonging to individuals? They tried that once. Can they pass such laws? They can pass such laws. Somebody has to review it. Somebody should review it. We should not take away the power of review.
Review, yes. But can the complete legislation be taken into its hands is the question on which I think...
Can I just ask you a question? Do you agree
Rahul
with the
Ishwar wants to come in. Rahul Ishwar.
Is it fair? Do you agree with the time limit being set? We know that there is a basic structure and nobody can violate. Everyone agrees with the basic structure doctrine. That was even put forth by Honorable Supreme Court. But do you agree with the stipulated time being put? How is there in the Constitution? It was not, envisioned by our founders. So how do you give a particular time to the President? Is it not a legitimate debate that we should have?
Definitely have a debate. Have a debate. Step back. Remove the aberrant governors. I just want to ask you, Ishwarji, was the governor correct in creating this kind of fracas on the Constitution? Please tell me, I'll accept it. Look at the way. What are the causes? You walk out of Tamil Nadu Assembly because the Tamil song has been for 25 years sung first. You walk out. What is this behavior? Why has nobody chastised him? It is the job of the government of India to see that it is not held to fault. In this case,
a lesser right should be corrected by a better right. That would be my submission. A lesser right should be corrected by Honorable Supreme Court's better right, or a much more refined version of right. I sincerely hope Supreme Court will definitely take into consideration, because this is not a party political issue. This is getting assent to the state laws without the signature of governor or president. That is going to set a bad precedent. So rather, it could have instructed the governor to go ahead, rather than saying that the laws are already laws, even without the assent.
I want to
gives debate.
Yeah, I want to get the others also involved in this. I will come to you again, Mr. Pulla Rao and Rahul Ishwar in a bit, but let me get in Anirban and Abid Mir Megami into it. Anirban, to you first. Nishikant Dubey gave the example of Section 377 of the IPC, the then IPC, and the manner in which Supreme Court gave a verdict which was against the sentiments of a great majority, right? Now, there are arguments pro and against, but the point that Nishikant Dubey is making is that Supreme Court perhaps is not in tune with the reality on the ground in terms of what people or majority of people believe to be right or wrong, like in the case of Sabarimala, so in the case of Section 377 of the IPC. Does he not have the freedom to express this thought, Nishikant Anirban, without being railed at in the manner in which the opposition has picked up on the comment made by the BJP MP? BJP also got defensive, but what about the freedom of right and expression which you generally defend on these debates?
No, absolutely. Nishikant Dubey can say anything that he wants. He can blame the CJI, he can blame any person for any wrongdoings all over the country except for the government, because he belongs from the BJP, and the BJP is basically above the law, above the constitution, above everything. Therefore, Nishikant Dubey has the right to do anything that
How
he
is
wants.
BJP above the law and
cannot touch
everything?
him,
That's
the
a
courts
sweeping
cannot
comment
touch
to
him.
make. Why are you saying so?
Because when a BJP MP says that the CJI is inciting civil wars, the first question that should be raised: where is the civil war? Where are the civil wars going on?
He said
in the
anarchy.
country,
He did not say
for,
civil war. He
Manipur,
said
maybe?
anarchy. This
Second,
can lead to anarchy is what he said.
okay,
There is no civil war.
the tweet from ANI that I saw.
In Murshidabad, there is civil war only. Let me state that.
Civil war.
Let me not paint a picture from the spokesperson of the party which is ruling West Bengal. There is a civil war. There is a genocide against.
You shut up for a moment, Rajat. Shut up for a
No,
moment.
no. He's making a point. He's making an interjection. He's making an interjection. You said there is no civil war. Rajat is saying there is actually a civil war in Murshidabad. Respond to that. Respond to that.
Two different communities.
I did not tackle him. Let me complete. Let me have my opinion.
Okay, Rajat, let him complete. Rajat, let him complete. Rajat, let him complete. I will ask your question to him. Let him complete.
Nobody cares about your opinion
Anirban, go on.
West Bengal, so please
Stop. Go on.
So now he is blaming the CJI for inciting civil wars or anarchy in your terms. Fine. So the BJP President JP Nadda says that they do not endorse that comment. Now let us for a moment consider that any MP from the opposition parties says anything vaguely similar to this about the CJI, or for that matter any constitutional body. What would the BJP say? The BJP starts the rants or their criticism with the term that anti-national urban Naxals, etc., etc. This is the starting point. Then they will go on to label people as terrorists and everything else. So just because this is the BJP MP Nishikant Dubey, he is above the law. That is what I am saying. My second point being regarding what Pullarao was saying, that he does not know whether other governors does this. I will say you, Pullarao, tell you that in West Bengal, starting from Mr. Jagdeep Dhankhar to Mr. C.V. Anand Bose, the same and similar thing is going on. Bills are placed in the state assemblies, they are passed in the assemblies, sent to the governor, and after that, nothing happens. Then neither do they sign it, neither do they refuse it. They simply push it into the back burner and keep it under the carpets maybe, and forget about the bills. That is almost the same things that happened in Delhi when the Aam Aadmi Party government was there.
Okay.
Therefore, what we are observing that in every opposition ruled states, the governors are basically, especially in West Bengal and Tamil Nadu, the governors are especially acting as BJP leaders. Therefore, the Supreme Court has very correctly
governors
stated
are acting as BJP leaders. You mean to say it has never happened before that governors have acted as Congress leaders or governors have acted as RJD, JDU leaders if their nominees were made governors?
Abhishek, the Congress has always faced accusations and allegations that they misused the post of the governor.
Have you forgotten Ramesh Bhandari? Have you forgotten how Ramesh Bhandari behaved?
When the BJP does the same, we have to accept that.
Abhishek ji, can I ask him about Article 200 and Article 201? Has he read Indian Constitution?
No, what is the point
before
you're making?
Before he on national television.
What is
Article 200?
Can I just point out? Can I just point out one thing?
Yes, Mr. Jotwani. Okay, Rajat, hold on. Mr. Jotwani.
Yeah, I'll just see, as far as putting a time limit on president and governor is concerned, I would make a hypothetical situation. Tomorrow, if a legislature comes and says that the Supreme Court has to decide a case in 6 months or 3 months, we all know that in judiciary, the cases are taking decades to decide, even in Supreme Court.
Absolutely.
So there has to be a kind of a balance between legislature. So Constitution envisages 4 pillars of this.
Absolutely,
there is
absolutely.
Course,
Anirban, that's a very,
what
very
you are
valid
saying,
point
the
Mr. Jotwani
governors-
is making.
the
And
governors
I am
can
agitated
at
about
any
this.
step-
400,000 plus cases pending, about how many 50, 60,000 cases pending in the Supreme Court also? Should we put a deadline that no justices, your lordships, please give away
No,
your,
so
give up your
your delay
vacations,
versus my
give up your
delay?
summer vacations, and please
Abhishek, is
take care of this
your
pendency.
delay
Can we do
versus
that?
my delay? The governors are doing this only in the opposition ruled states. They are not doing this in the BJP ruled states. So therefore, there is a clear politics at play. Whether the judiciary needs to reform itself, speed up the processes, absolutely. We are all in confirmation with that. But in the case of the governors, you cannot correlate these two. You cannot draw a comparison between these two. The governors in the opposition ruled states, they are intentionally delaying
that
the
our
process.
constitution fathers, the makers of our constitution, were not aware that these things can happen? I think there must be a reason why this provision that the president can sit
Abhishek-ji, I'll
over
tell you,
a legislation
these two
for an
articles were brought in-
unspecified period of time is there with some thought.
Yes, but did our constitution makers also rather think that the governors in opposition ruled states will keep the bills at bay for infinite number of months and days? Is that what Baba Sahib Ambedkar thought?
Yes, Rajat,
that
Rajat,
in opposition
Rajat,
ruled
now let
states
me
only,
tell
the
you,
governors
there
are
are two
allowed to not
articles
sign
in
the
Indian
bill,
Constitution
not send
which
them
look
back and do nothing.
Which look at the governor's veto power. Governor's veto power, underlined word is veto power. There are done for like multiple objectives which Baba Sahib's drafting committee carefully went through. We were at that time a country in the formation, a loosely held federal structure where we wanted to ensure that no state legislature comes out with a hasty or an ill-conceived legislature. This was the reason why Article 200 was brought in, and similarly, Article 201, which allows president's veto powers, was also brought in. I need to understand the constitutional basis where Supreme Court steps in and challenges these two articles of our Indian Constitution. We need to understand that these were cushions which were built in to keep those outlier events under checks and balances. What if a state legislature comes up and comes out with a statement like, I want to separate from the Indian Union? What will happen to that? Should the governor not be there to stop such kind of legislations being adopted by any legislature? 100% they should be.
No,
and this is the reason why this delicate balance between a unity structure and a federal have some decent, well-educated conversation. Don't blabber like a party spokesperson.
How is the governor in West Bengal or Tamil Nadu helping? By doing nothing over the bills.
Judge for that. You are not the judge for that. This is where the Supreme Court needs to step in.
3 months, 4 months, 8 months, over a year.
You see, the provision is very clear.
Or you say no.
The governor
must say yes
Do you
or
want
he must say no. He cannot
you want to
sit over
tear
the
aside
bill
Baba Sahib's
for
constitution?
decades.
Do you question his understanding of India's structures, India's polity structures?
You are suddenly.
It is Baba Sahib's well thought out, well reasoned articles which included in our constitution avoid any kind of a reckless move by a state legislature. A state legislature like West Bengal tomorrow cannot come with a legislation which is against India's rights, against India's boundary rights. Those are fundamental things the legislature cannot step in. And you need to have a governor to put checks and balances on state legislature.
Dhankhar had targeted those judges who had framed that particular doctrine, the basic framework doctrine. He said that those people were anti-nationals.
What are you talking? How is it going against basic structure? Come educated or you come here just to blabber and waste time of states. How is Article 200 against basic structure? How is, let us talk specifics. How is Article 200 or Article 200 against the fundamental basic structure of our constitution?
You are trying to hide behind Ambedkar right now.
When you get people who are rowdies of a political party, they can't make a comprehensible argument. Okay, we are talking about constitution.
Rajat,
you are an RSS man. You are an RSS man trying to hide
Anirban, Rajat, please both of you pull back. Anirban, Rajat, please both of you pull back. Please pull back. Anirban, let me take this back to Pullarao. Let me take this back. I have to also get in our Congress representative also in this conversation. So, Mr. Magami, I'm coming to you just in a bit. Pullarao, there is a backdrop in which the center perhaps is showing this extra sensitivity in the case of Tamil Nadu. We have seen under MK Stalin, Tamil Nadu taking or behaving in a radical manner, including the latest example by way of the autonomy resolution that has been passed by the assembly. Pularao, Mr. MK Stalin, because he wants to win the next year's elections on the platform of Tamil chauvinism, to put it mildly, is perhaps pushing the envelope a little too far. And that is the reason why the centre is cagey in terms of all these bills that have been sent and that need passing. So obviously that is the reason why this delay has happened, or the governor has not, given assent or sent them back to the assembly. These bills are politically motivated is the charge.
If that is the intention of the centre, it's a very ham-handed, amateurish way of dealing with it.
It's not ham-handed, it is part of the constitution that if the bills are such that they can impinge upon the unity, integrity of India on the constitutional scheme of things, on the mechanisms already in place, the state, the centre can obviously review, put under review, or can, withhold assent to the bills. It's constitutional.
You see, long ago, all the Dravidian parties gave up this autonomy business when Annadurai was there. History will tell you, and Ishwarji will confirm what I'm saying. It is over. It's a dead issue. Otherwise, how would DMK have been defeated at the height of the Sri Lanka issue? That's a dead issue. And I think I may very much, definitely you're overplaying this issue. The autonomy and people, it's a regular sound we have been hearing in Tamil Nadu since 1920. And then more accentuated worse now, then I think it should not be taken like that. And then if the best way for the centre to deal with such issues is, the centre should be a referee. The centre should be above all these things and try to rein in governors or other. By the way, you remember how very dismissive way a minister in the government of India spoke about, take it or leave it. Is this the way you deal with the chief minister of a large state in India? Is there no place for any courtesy? These things hurt people, they react. The central government has a responsibility to take everybody along and show
Rajat, the point being made is,
to highlight this autonomy issue.
Bizarre argument, Abhishek ji.
Pularao, by the way, you deflected my autonomy question, but I'll come back to it. Before that, Rajat, this question, of course, has to be answered, which Anirban asked. That, okay, fine, this is constitutional mechanism, there are provisions, part of the constitution, but why is it that most of those bills, assent to which is being withheld, are happening in the opposition-ruled state? So obviously there is a gridlock that's shaping up.
No, because it's very simple. When you have same governments in the center and the state, no state government dares to do any kind of craziness, any kind of an entrepreneurship on testing the boundaries of our federal structure. It's only these confrontation paths come in the states which are in opposition. It's as simple as that. Plus, there are other mechanisms when there is a same government in the state level, in the central level. There are many such mechanisms to address any kind of concerns. Where is that mechanism in two states, in a state where there is a different government and in the center there is a different government, and where the chief minister doesn't even have the basic courtesy to go out and receive the honorable prime minister when the prime minister is visiting that state? This is the level of courtesy which is being accorded to him. So let us now come out of this charade that, okay, why is it only against the opposition? Why does opposition not come out and create avenues that there are, other than the more formal one, there are those informal structures where they can reach out to the central government if there is a genuine grievance? Look at the policy, the NEP, the National Education Policy. These ministers and these members of parliament from Tamil Nadu, they come in and have separate discussion closed door. When they go out, they need to do politics, because what is life without politics? So they will go out and do all kind of politicking, and then the whole bill and the entire logic they had agreed to is thrown into the dustbin for the entire population. That is the real problem. Now tell me, where is those informal structures to address this issue other than direct confrontation, where governors, unfortunately, the governor's office comes in the crossfire between the two institutions. That is the real challenge.
Yeah, absolutely.
Don't ascribe to political motives that directly.
Okay. Mr. Magami, if I can get you in now, Abid Magami, Constitution provides that constitution amendment bills, for example, can only be brought in parliament. It's beyond the prerogative of the state assemblies to have constitution amendment bills. Now, in the backdrop of this autonomy resolution, which Stalin government has brought in, and the committee that they have set up saying that they want to speak for rest of the country and other states also. Now, it's a dangerous precedent. Tomorrow, if these states push the envelope even further, and instead of an autonomy resolution, pass a law that, okay, fine, we want to amend the constitution also. If, say, 12 states get together and say, okay, fine, this is as per population, if there are big states, they are a majority of the population of the country, and then if they say if 12 states come together, they should be allowed to pass a constitution amendment bill, we are looking at absolute anarchy in the country.
जब कानून बीजेपी के फेवर में होती है तब सुप्रीम कोर्ट ठीक होता है। जब आर्टिकल 142 के तहत बाबरी मस्जिद का फैसला दिया गया था तब ठीक था, तब सुप्रीम कोर्ट अच्छा था। जब आर्टिकल 370 पे पास किया गया सुप्रीम कोर्ट ने तब ठीक था। आज इसी सुप्रीम कोर्ट ने जब फटकार लगा दी सरकार को तो सुप्रीम कोर्ट विलन हो गया एकदम से। यानी कि जब फैसले गवर्नमेंट के हक में हो तब ठीक है, जब गवर्नमेंट को अकाउंटेबिलिटी करे सुप्रीम कोर्ट तब सुप्रीम कोर्ट विलन बन जाती है।
ये आर्गुमेंट तो आप पे भी लागू होता है।
जब एक स्टेट को यूटी में कन्वर्ट करते हैं तब ठीक है, तब बीजेपी के लिए ठीक है। जब बीजेपी को सुप्रीम कोर्ट फटकार लगाती है, राज्यपालों को फटकार लगाती है, 1.5 साल बिल्लू को रोकती है, तब बीजेपी को मिर्ची लगती है कि सुप्रीम कोर्ट के ऊपर उंगली उठाती है।
Mr. Jotwani, the point is, the opposition argument is that is the BJP being selective here? That when the Supreme Court gives favorable verdicts, it's fine, fantastic, victory of constitutionalism. If there are any judgments which sort of go against the BJP or its political objectives, then you get all these voices attacking the topmost court of the country.
See, this is the nature of judicial process in this country. If you see, one party will be happy and the other party will be unhappy. You know, as was mentioned, there are times when Congress is unhappy. There are times when BJP will be unhappy. The point is that we all need to respect the judgment. We all need to have patience to see, and there is a process, inbuilt process is there. I know like what is happening in Tamil Nadu right now, and there is an extra committee being formed to review the constitutional provisions. So all that may be done, but at the end of the day, there is a Supreme Court. It's a savior. Article 142 has been used again and again since beginning, and we have seen very landmark judgments that have come in favor of the country. I know there have been judgments which have been not liked by Congress party, or they have not been liked by BJP or Aam Aadmi party. So that will always remain. It will always continue that one of the party will lose in the court and the other party will win in the court. But having said that, the respect for the Supreme Court that is there should always be maintained. The kind of language that we use from both.
Mr. Jotwani, I have to come in here. Coming to you, Rahul Ishwar. You know, Mr. Jotwani, just a couple of points. On the NJAC, the Supreme Court overturned a parliament-passed law, binned it. We have seen on the issue of, for example, when the Vice President made these comments that Supreme Court is not having accountability. In the case of, for example, the burnt cash episode that has happened recently, the Vice President said, where do you find a situation where Supreme Court or a court arrogates to itself power of investigation? Under what law? So obviously, Caesar's wife should be above suspicion, as they say.
Yeah, I have always maintained that the justice should not only be done, but it should seem to have been done. In the cash being found in the premises, that was a case where we had the judiciary being put on the dock, as I will say, is put on the trial right now, and we have to see how finally this episode judiciary is able to tackle. That's like a big blot right now with the legal system itself, I will say. But let's not mix the two issues at this point of time. There are provisions in the Constitution of India. There are legal provisions that can be taken by both the parties. If we see what is happening, Tamil Nadu is creating a kind of a committee to look into some, from the Constitution perspective, what should be the power, what kind of power it should have. Now, again, that will also be a part of the review that can take place in the Supreme Court of India. So let us not lose hope. Both the parties, I will say, let us not lose the hope. There is nothing, and let us not at least tarnish the judiciary.
I'm not tarnishing. Nobody's tarnishing the judiciary for the. Let's be very clear. Nobody's tarnishing the judiciary. We are asking questions, and if you agree,
just one submission.
Rahul, go ahead.
No, I am a proud Indian from South. Whether we belong to North, South, East or West, the entire thing makes sense because there is an India. So I'm an Indian from South. There is no space for, more any kind of wrong or, I'm sorry to use the word separate mindset. I won't even use the word separatist, separate mindset. See, we need more integration.
No, there is a latent separatist sentiment in the country in many pockets, many quarters, Rahul Ishwar. Let's be very upfront about it. And that is the reason why the Constitution fathers in their very right wisdom decided that let there be a centralizing tendency in the country despite its federating units. It's part of the plan. There is a reason why the president has even more overriding powers of veto over state legislation vis-a-vis the central legislation.
And we have a unitary nature to constitution and also a federal nature to constitution. We can say it is something like a quasi-federal or a semi-federal. And that's the reason why I don't want to use the word separatist, but no kind of separate mindset should be there. We are Indians first. I'm a proud South Indian. I'm proud of the Tamil language, which is the oldest language. And we have a PM who goes around the world telling that we have the oldest civilization in the world. No kind of any separate mindset we should encourage. Yes, there may be debates. We are family at the end of the day. We may have different viewpoints.
Okay.
But the whole idea of autonomy, separate, let us having fight with the other is unfortunate. And even the rupee symbol. See, so many things, it adds up to the entire thing. So I have, with great respect to Thiru Stalin and all the India bloc parties, this is not the way. You debate with Modi ji, there's no issue. But the larger Indian framework needs to be safe.
Anirban, you see, Anirban, let me ask you a question and then you answer. Anirban, my question is that Nishikant Dubey is getting panned for saying, one of the comments he made was that according to Supreme Court, you show me the face, we will show you the law. Recently, in the Teesta Setalwad case, the Supreme Court opened on a day of chutti, I think, or maybe the case got mentioned on a day of chutti, or I think well past office hours. I don't recall correctly. Just today, Anirban, you were saying that the governor should not act as BJP representative in the state. West Bengal Police, Anirban, has retweeted or reposted a letter of Chief Minister Mamata Banerjee in which she is making direct charge against the political opposition in the state, which is the BJP. She even names RSS. Why should Bengal Police get into this, Anirban? Should police act to amplify a political message of the Chief Minister, Anirban?
Okay. First of all, even though I support the particular message by the Chief Minister, but let's for a moment say you are actually criticizing this reposting of the particular message by the West Bengal Police, right?
I'm asking you a question.
So in the same note, I'm telling you, since you're asking a question, that is the same kind of question we're asking of the governors. That when it comes to opposition states, why do the governors act in one particular way and for the BJP ruled states in another particular way? In this case, what I was trying to mention, that Kiren Rijiju, first Jagdeep Dhankhar in January 2023 called out the Keshavananda Bharati case. And he said that he does not agree with the basic doctrine principle. In March 2023, Kiren Rijiju, the then law minister, I think, he says that some of the ex-judges are part of the anti-India gang. And after that, they were basically arguing for removing the collegium system and bringing the particular appointment system.
Ex-judges do not constitute a court.
We saw
ex-judges do not constitute court. They can absolutely be criticized. Ex-judges are absolutely normal citizens of the country.
Ex-judges anti-India gang. So you can call ex-judges anti-India gang without any proof whatsoever. If they did something anti-India, where is the prosecution? Where are the cases? Where are the FIRs? No investigations. Simply,
but my question,
them.
my larger
You
question,
call
my
anybody
larger
that
debate
you,
this evening
even
is
ex-judges
Anirban.
that they're anti-India. No, the particular part is that the BJP, the way they took over the Central Election Commission by bringing in an ordinance overturning the Supreme Court's ruling, they also want to take over the judiciary in its entirety. Because the judiciary seems to be the last hurdle they cannot cross. That they are taking over of the entire country, of entire constitutional framework would be complete once they take over the judiciary.
Okay.
So therefore, this is the way they are attacking the judiciary. If they can dismantle the collegium system, the takeover will be complete. And to answer Rajat, the state governments are elected by the people of the state. If the opposition parties are elected by the people, they are under no obligation to bow down before the union government. They will pass bills that their people want, not what you want. The India is not
You have a very
paternal
understanding of India's constitution and India's
is not
framework.
a paternal property of the BJP.
You should go and study
the
constitution
BJP cannot dictate the states or the opposition parties as to what to do. Therefore, the people of the state will decide what the government will pass in the assembly. And there are opposition parties to debate that particular bill or bills in the assembly. The governor cannot simply sit over them for months on end or more than a year, more than 2 years. They cannot simply sit on the bills.
But India's constitution allows him. So let me tell you, when you have discussions, you should keep your political hats aside so that you can talk about the subject. The problem here is that, unfortunately, and I see this repeatedly, when people on the other side come in, they don't want to talk about substance. We're talking about that why is Supreme Court having two different yardsticks for two different cases which are coming to it. That was the question that was put up. Now, instead of answering that simple question, we are going around in circles with a very, very shallow understanding of India's constitution. If people of our country, of a respective state, elect a state legislature, they elect it only on the state list. They elect that legislature to only legislate on those specific lists.
And concurrent list also.
Mentioned in Constitution. Now, go and first study Constitution before you come out and discuss. That is the challenge. People who come out and discuss don't know our constitution. And if I ask you honestly, you will not be able to mention
there is man.
RSS
denounced the constitution.
Discussions on Article
Anirban, talk about the present. Anirban, talk about the present. Rajat, pull back. I have to get in more points. Okay, is there, Rajat, you made valid point. You see, it seems that the states and their present ruling dispensations perhaps are misreading the unitary provisions of the constitution or tending towards a stronger center for a very specific reason, that you need to preserve the territorial integrity and sovereignty of India. Rajat, I think in the case of Vice President, he sort of got misled by the headlines, because you see, when the Supreme Court has put this 3-month deadline on President of India deciding on legislations, I think the Supreme Court very smartly drew out from two office memoranda of the Ministry of Home Affairs themselves, of 2016, which sought to fix the deadline for President. So I have not read the details per se, but then it seems that the Supreme Court has really played smart on this pegging of 3-month deadline for the President also.
No, I don't think that is the case. Over here, the Supreme Court has been trying to interpret the powers of the president when the case wasn't even made out for president's office. I think that is where the clash happened. And I think vice president is not a small office. You tell me, where do you have constructive criticism of an institution? It is we the people.
Well, one newspaper at least thinks that's a small office.
Small office, I agree. But you people have reduced these offices to something to turn them into mockery.
They should actually look into it.
Both houses of the parliament to mockery.
They should actually,
there is a reason why all this is happening. There is a reason why this is happening, because the politics are so contested in the present times. Look at, and I will give the last word to Mr. Jotwani before I wrap up. Look at this funny aspect of it. Even before the Waqf Amendment Act was passed by both the houses of parliament, states like Kerala, Tamil Nadu, among others, they even passed a resolution opposing the Waqf law. I mean, such desperation to pander to your vote bank slash constituency, Mr. Jotwani, that politics has really taken over process and constitutional propriety, it seems.
Yes, I think our constitution clearly laid this down, that this is what the center will legislate, this is what the state will legislate, and this is what the concurrent list will be there. So once the matter is being debated in Parliament, not only Parliament, there was a Parliament committee also set up for the Waqf Board. So passing of these legislations in the State Assembly could be easily challenged. And of course, what we saw subsequently was governors again did not allow these because there was a pending legislation already there in the Parliament that was being taken place. So these kind of constitutional anomalies will definitely come if the governor feels that there has been an overreach in any legislature, which is actually which is within the ambit of the central list in the Constitution of India. They may still come and they may still, stop that overreach. And this is what is actually happening if there is a legislation that the center feels or the governor feels that this is something overreaching. Of course, ultimately we have courts to decide. Article 142, as we talked about, is there, which will make a decision.
Right.
But our constitution is very, very clear about these
right, Mr. Jotwani.
And we should not overreach.
I can still see Rahul Ishwar raising his hand, and I would have still wanted to come back to Pullara once, but I have really run out of time. Sorry, Mr. Magame, I couldn't have you a little more than I would have wished to, but I have run out of time, as I said. Anomaly is the word I pick up from the last comments made by Mr. Jotwani, and unfortunately what we are seeing is a churn, not all of it good for the country, but what is important to understand is that over the last 70 plus years, the Constitution, 75 years now, the Constitution of India has really held its ground. It's a fantastic, fluid and organic document which has made sure that the centripetal and the centrifugal do not lead to any fracture in the country. And I believe in this case also, this churn also, in the fight between the states and the center, the centripetal would win over the centrifugal. Thanks for watching, friends. Short break, news is on the other side, and tomorrow 8 p.m. Super Prime Time Max with Arnab Goswami is back. Be right there.